So our last session of the workshop today, we will be talking about the more legal aspect of how to hold the perpetrators of enforced disappearance accountable in a court of law. And I don't know if we have any legal professionals, lawyers here. Do we have any lawyers? Oh, I'm sorry. Yeah, Ms. Min. Yeah, so we do not have that many lawyers today, I believe. But I was. This is something that constantly came up in the previous sessions, previous talks too. But at the end of the day, the evidence, data, information that we collect will see a day in court, hopefully, and it'll be all these evidence will be presented to judges, prosecutors, lawyers for their legal determination. And I think it was in the previous presentation by, was it Nico or Tony? But so the phrase like, will the judge understand, or will the prosecutors actually be able to represent all this, and will it be presentable to lawyers, defense counsels? That really struck a chord with me because I always have this legal background. But it's really important that we have a good understanding of the law, and long before any like trials or any prosecutions begin, from the time point of the initial human rights documentation, because what will later become legally significant details, they're not so obvious to the human rights documenters. And in the case of enforced disappearances too, I think it would really help if we understand like what kind of elements, what kind of requirements will actually stand up in court to actually convict somebody who is responsible for these disappearances. And this is particularly because we are trying to do a real trial in a real, like a genuine court of law with all the due process, the principle of legality. This is not some kangaroo court that we see so often in North Korea and elsewhere. I mean, it would be much easier if it were like we were trying to hold trials for these perpetrators in North Korea, for example. If all you need is like Kim Jong-un telling people to just like find this guy guilty and just execute him, that would be super easy. But obviously that's not what we want, and we actually want to have a solid legal case based both on the law and the evidence. So as we prepare for this workshop and also the international conference, we came across this very interesting case from actually a local court in Switzerland, that where the suspect of one of the enforced disappearances that had taken place about 20 years ago in Belarus ended up in Switzerland and actually stood trial. Although the trial is still ongoing on appeal, it was we thought it was very interesting to hear how all this legal drama has been playing out from someone who was deeply involved in this process for many years now. So that's why we've invited Alexandra to this conference and this workshop, and let's welcome her with a warm round of applause.
You have the 65 minutes?
Oh
yeah,
my God.
65 minutes.
Yeah.
So up to 5:30.
Great. Well, thank you so much, Ethan, for this kind introduction, and thank you to the TJWG for inviting me to speak at this conference and this workshop. It has been an extraordinary experience to learn from the other speakers, and I'm very happy that you're here today. So thank you so much for attending this workshop. My name is Alexandra. I'm from the International Federation for Human Rights. For those who might not know us, we are an international human rights organization based in Paris. We have 188 member organizations all across the world, including in South Korea, and we work on promoting human rights and accountability, including through strategic litigation on the international but also on the national level. This is why today I have the opportunity to speak about the case preparation for domestic courts. And I would like to preface this workshop with a short disclaimer. First of all, as we already heard during the presentations yesterday, but also today, and you know, every jurisdiction is unique. So the legal judicial system in the countries, including the rights and the roles of all actors involved, but also the rules on evidence, which can be very important for the documentation by NGOs, may vary significantly. So this presentation rather seeks to raise awareness for these questions and for some of the challenges that may arise throughout different jurisdictions. There are unfortunately no universal guidelines or instructions I can share today, but I will try to do my best to share some practical insights and some practical experience with you. Today, as you have maybe already seen, this workshop will be divided into two parts. There will be a rather short theoretical introduction, and then you may have seen that we have distributed a case study. Thanks a lot for the support of our colleagues with that. Yeah, so I think I'm just start with the rather theoretical part. Please feel free to how do you say? Oh my God, to interrupt me at any point if you have any questions. So I would like to start with the notion of strategic litigation, because I think that this is our starting point. As you maybe know from experience, NGOs often have limited resources. This includes personal resources, this includes temporal resources, this may include budgetary constraints, but maybe also limited expertise or limited experience, access to territory, access to victims, witnesses, or evidence. Therefore, not every case that an NGO would love to work on or works on will in the end be brought before a court. So that's why strategic litigation is important, and there is no universal definition of strategic litigation, but if you have a look at different approaches, then I think this is something that is pretty universal. It's the selection and pursuit of legal cases to create impactful and lasting legal, political, or social changes that go beyond an individual case and expose injustice and empower those affected by human rights violations. Strategic litigation is often accompanied by a larger and is part of a holistic campaign. It's not only the trial, the preparation of a case, and the documentation, but it includes also advocacy, communication, and community outreach. And this requires that NGOs become sometimes pretty creative, but first of all have to define the goal of their campaign. As we have heard several times throughout the other presentations, sometimes it's very important to define what your goal is first, and this can vary a lot. It can be justice, whether for the individual victim of the affected case or for the affected community as a whole. It can be financial reparations, but it can be also legal, institutional, or political changes. So maybe with your case, you would like to set a precedent in a jurisdiction. Maybe there hasn't been such a case in this jurisdiction before, or maybe it's even the first application of a criminal provision as we had in Switzerland. It can only also be that you would like to achieve political changes, that existing policies are changed or that new policies are introduced that are more protective for those who are affected. It can also be that you would like to clarify the law and that you would like to achieve an interpretation of national law that is in accordance with international standards. So it's really about creating a campaign first and defining your goals first. Some indicative criteria for strategic litigation can, for example, be is the case backed up by sufficiently strong and available evidence, and what is the likelihood of winning a case? But it's not only that, it goes, as I said, beyond just the expectation of winning or losing a case in court. It's also a question of, does the NGO and the coalition of NGOs, its partners, do they have the capacity and resources to take on a case? It is also a big question of in which jurisdiction a case can be filed. And is there a favorable legal or political environment for litigation actions, for advocacy, and for communication? Then what are the potential positive and negative outcomes of winning or losing this case? What are the risks for the affected community, for maybe even your NGO or the coalition of NGOs? And yeah, as I said, what does this case mean to the affected community? I think that very important is speaking about a victim-centered approach first. In enforced disappearances, it's actually a very interesting case because, of course, the person who was disappeared is a victim of enforced disappearances. But in addition, international law also considers that family members of those who disappeared can be direct victims, and therefore in legal proceedings before a court, they may have potentially certain rights and obligations. For us, a victim-centered approach basically means placing the dignity, the rights, the interests, needs, and the security of victims at the center of all actions. And this principle flows more generally from the do no harm principles that, of course, your NGOs know very well. So how can this look in practice? First of all, I think from our experience, it's managing expectations. Very often, victims may have high expectations and they hope for justice for the disappearances that happened. But we also know that often procedures before the court can take a lot of time, sometimes many years, or maybe they do not even come to the trial stage. So it's really important to explain the victims what they can expect and not promising something that we as an NGO cannot hold. It's also about conducting a risk and security assessment. I heard that we already spoke about the risk of retaliation, and that's why it's important to know the risks as good as an NGO can assess them at the moment, as of course they can change. It's also about taking all necessary measures to avoid re-traumatization, including during the documentation phase. It's ensuring that medical, psychological, and financial or social support is available not only in the beginning, not only during the documentation, but throughout the proceedings. It's basically about accompanying the victim throughout this sometimes very long procedure. And it's also ensuring that a victim plays a leading role in the proceedings and is included in all relevant discussions and decisions, not only when it comes to the trial, but also when it comes to advocacy measures, also when it comes to communications campaign. We already heard the term informed consent, so I think this is key when it comes to the victim-centered approach. The next part of this presentation will be a bit technical. I apologize for that. But at the same time, I think that it's extremely important to know the legal basis and to understand what jurisdiction means. So basically, where can a case be filed? A case can be filed where a court has jurisdiction to hear the case. And there are different types of jurisdictions that we'll go through in a second. It's subject matter jurisdiction, territorial jurisdiction, and temporal jurisdiction. And a court needs to have all three jurisdictions to decide a case. What is subject matter jurisdiction? It is basically the question if enforced disappearance is a crime under the jurisdiction of the state in question. And here, as you know, there is an important difference in at least many states between ratifying and signing an international treaty and implementing national legislation. Because for a national court to act, there needs to be a criminal provision in the national legislation of the country. And unfortunately, I have not found any numbers on how many states have criminalized enforced disappearances. But basically, there are two big treaties we already heard about yesterday. Enforced disappearances is a crime under the ICC Rome Statute. It is a crime against humanity, or on the UN Convention on Enforced Disappearances. So what we know is that 124 states have ratified the Rome Statute and are thus obliged to criminalize enforced disappearance as a crime against humanity. We also know that 75 states have ratified the UN Convention on Enforced Disappearances. However, it is also well known that not all states have obliged by the obligation to criminalize it in its national jurisdiction as an autonomous offense. And coming from Germany, I can say that Germany, for example, ratified the UN Convention but never actually implemented this legislation, at least so far. So coming to the second type of jurisdiction, territorial jurisdiction, here the question is, in which state can a case be filed? And as you know, of course, states exercise jurisdiction within their own territory. So if a crime is committed in the territory of a country, then national criminal courts have jurisdiction to rule about it. But additionally, there is a type of territorial jurisdiction that is called extraterritorial jurisdiction. So the crime is committed outside of the country. And there are three different principles, the most important of which is universal jurisdiction. There is the active personality principle. This basically means that a perpetrator has the nationality of a state. So for example, if a crime is committed by, let's say again, a German national, but in another country, under the active personality principle, there can be jurisdiction for a German court to rule on this crime. Passive personality is the same, but is about the nationality of the victim. So if a crime is committed against a German national somewhere abroad, then German courts could have jurisdiction depending on whether Germany has implemented this or not. But as I say, the most important one is universal jurisdiction. And universal jurisdiction means that a state can investigate and prosecute a crime, although there is absolutely no link between the state and the crime. Yesterday I had the opportunity to speak of the case of Yuri Haravsky, a Belarusian national who participated in the enforced disappearance of 3 Belarusian opposition figures in Belarus. And nonetheless, a Swiss court had jurisdiction to rule about his case. So universal jurisdiction is a very important tool for criminal accountability and justice. However, I would like to briefly mention that universal jurisdiction sounds like a very simple principle, but there can be limitations. And in fact, some states have introduced additional limitations to this principle. I will just quote one of the examples, which is France. France has universal jurisdiction for many crimes, but additionally, for example, one of the criteria is that the perpetrator must be a resident of the country. So if you have a perpetrator who comes to France but is not a resident there, so he does not spend a sufficient amount of time in the country and does not live there, the court would, however, not have jurisdiction to decide about his case, which of course is problematic for us. And I would also like to briefly mention that most jurisdictions are very cautious about investigations and trials in absentia. They are not automatically prohibited under human rights law, but nevertheless many states do not accept or accept only exceptionally trials in absentia, which of course makes it very difficult to achieve accountability in national courts. And the last question of temporal jurisdiction is, was enforced disappearance already criminalized in the jurisdiction in question when the crime was committed? So we see that certain states have implemented the Rome Statute or the Convention only recently, and at least after the deprivation of liberty was already committed. So in general, in I think most or all criminal courts, there is a prohibition of retroactive application of criminal law. So if a crime was committed before something was criminalized, the perpetrator cannot be held to account for that. But enforced disappearance is considered a so-called continuous crime. This means that the crime is not completed until, as you know, the state has acknowledged the deprivation of liberty or has informed the relatives of the fate or whereabout of the victim. So the crime continues and is not bared with limitations. And finally, speaking about the favorable legal environment, as you know, there are many factors that are not part of the legal procedures or of the national law, but they, however, influence how successful a court case could be. For example, how stable is the legal and judicial system, how progressive or how conservative is it, And do national provisions allow for a meaningful participation of the victims? These are just some of the questions we could keep in mind. As we saw, NGOs can sometimes have very limited capacities, and from our experience in this case, it can be very important to conclude and build coalitions or partnerships with other actors, which includes other NGOs, whether international or local, whether specialized in a certain area and a context or specialized in international litigation or criminal law. It can, of course, also be very interesting to work together with investigative journalists, with activists, or with data experts, as we have seen today. And as I said in the beginning, the role of NGOs in domestic courts can vary significantly. And this can have a lot of repercussions for the case. For example, not in every jurisdiction an NGO can file a criminal complaint or become a civil party in a criminal procedure. So the role of NGOs often consists in preparing strong evidence for a case, in facilitating the whole procedure, in ensuring that the victim's needs and voices are heard, and accompanying and supporting the victim throughout the process. And this includes, interestingly, the cooperation with lawyers, because although in many NGOs there are legal experts and even lawyers, especially if you have a case on universal jurisdiction, you will need to interact with another national legal system, and this also means that a lawyer must be admitted to the bar in the country he or she practices in. So it is important to find an experienced and committed lawyer, and here partnerships with organizations that are based in the country of the future trial can be key. And it's also important, at least from our experience, to find a suitable way of cooperation between all the actors that are involved, whether the NGOs, whether the lawyers, and the victims, to share information in a timely manner and to ensure that everyone is aware of the proceedings and how the case is going. So coming to the question of how to build a strong case, as we've seen, enforced disappearances is criminalized in the national proceedings on two legal bases. It's either enforced disappearance as a crime against humanity or enforced disappearance as an autonomous crime. And I have here the example from the Rome Statute, which we have seen yesterday already. And I also have the article from the convention, from the UN Convention. We have analyzed the law yesterday, and in the case study that you have received, you will also be asked to do that. So I'll be skipping this part and just very briefly speak about the main two differences that I think are relevant here. The difference between enforced disappearance as a crime against humanity and the convention is, first of all, that for crimes against humanity, we need the so-called contextual element. This means that enforced disappearances must be part of a widespread or systematic attack directed against any civilian population. So it's an additional criteria that you would need to prove if you decide to file a case on as crime against humanity. And there is also an interesting difference in the wording of the Rome Statute and the Convention. The Rome Statute says that an enforced disappearance must take place with the authorization, support, or acquiescence of a state or political organization, whereas in the Convention, it's only the acquiescence of a state. And I think that it's very interesting to think of the consequences this may have, especially in the context of Korea, and we'll speak about this later in the context of the case study, for sure. So we're coming to the case study now. Please have a look at the paper that you have. I think it would be great if we dedicate about 20 minutes to this case study. Please read it. It's either in Korean or English. Let me know if you prefer or need the other version. You have 20 minutes to read this case, and it would be amazing if you could form groups of 2 or 3 people and start discussing the questions in this little group. And after that, we'll have some time to discuss the questions together, to compare the different approaches. And if you have any questions, we'll also discuss them later. So have fun with the case study. Okay, I think time is up now. So thank you so much for participating and for engaging with this case study. I would suggest that we just briefly go through the 6 questions, and I'm really looking forward to hearing your answers and also hearing from your experience and discussing with you, because you may have noticed that the case is loosely based on the situation that is similar in Korea. So I'm really interested to hear your answers, and let's just start with question 1. You want to prove that Y's case amounts to an enforced disappearance. Where do you file a case and why? Okay. Any ideas on this very technical first question? Okay, that's normal. That's the first question is always the hardest one. Maybe let's discuss together then. So as you have seen, we have 2 states. We have State B and we have State C. State B has ratified the Rome Statute and has implemented the necessary legislation, but has not ratified the UN Convention. So in this case, we don't have any national legislation from the convention yet, but we have the Rome Statute. And that's why we have subject matter jurisdiction in this case. But there is an obstacle, as we see in the footnote, because in the national legislation, as we saw in the beginning in the presentation, sometimes there are limitations. And in this case, the article says the suspect must have his or her usual place of residence in State B. In our case, if I'm not mistaken, our potential suspect is in State C. So unfortunately, there is no way to file this case in State B. Is there an opportunity to file the case in State C? We see that the state has ratified the Rome Statute and implemented the necessary legislation, and it has also ratified on the international level the Convention on Enforced Disappearances, but has not implemented the necessary legislation yet. And as we saw in the beginning, this is unfortunately not an exception. This happens quite often. So when it comes to the convention in State C, we cannot file this case yet until the state implements the national legislation. However, we also have here the Rome Statute and the national implementation. And as far as I see in the footnote, we don't have any limitation on the principle of universal jurisdiction. So here in this case, we can file the case in State C, which is actually very good because we have seen that the alleged perpetrator is in the state. And in practice, as we have seen, many states that have universal jurisdiction tend to wait until the perpetrator is in the territory of the state before actually opening investigations. So the presence of the suspect in the territory is really crucial. And yeah, the result is that we can file the case in State C. The next question is, which elements do you need to prove? And here, let's see if you remember or if you had the moment to have a look at the Rome Statute. If not, we can also do it just all together. I guess this will be easier. So as you know, for enforced disappearance as a crime against humanity, we need the arrest, detention, or abduction of a person. And this must have happened with the authorization, support, or acquiescence of a state or of a political organization, which is followed by the refusal to acknowledge the deprivation of freedom or to give information on the fate and whereabouts of the person. This is the actus reus, the so-called. So these are basically the elements that we would need to prove and to document. And in the next question, we see that we will need to choose evidence from the case. And here I'm really curious to hear which evidence you could use and you would choose from this case study. So maybe someone has an idea on witnesses, potential evidence, any other material that we could use in the case we are filing.
가해자 증언이요. 가해자가 증언을 해야 돼요. 여기 보게 되면
Sounds great.
네. A국 보안국의 현지 구성원이 2명 중에 1명이 예, 가해자로서 그 가해자가 증언을 해야 된다고. 그 굉장히 중요하다고 생각을 해.
Any other ideas? I think.
네, 일단은 방금 그 우리 최민경 피해자가 말씀하신 것처럼 그 기존에 이미 그 A국을 탈출한 비밀 경호 고위 관리들의 증언, 특히 인터뷰 언론에도 나왔던 그 증언들 있고요. 그리고 가능하다면 그 A국 출신 2만 명의 증언들을 조사할 필요가 있다고 봅니다. 그리고 탐사 보도 자료에는 판결문이 있었기 때문에 그것도 참고할 필요가 있고, 또 그 뒤에 나온 A국 보안국 전직 구성원 2명 중에서 1명이 바로 그 아들을 처형한 당사자입니다. 이분의 증언이 필요한데요. 지금 입증하기 위해서는 지금 2번 질문하셨나요?
Yes, exactly.
Number 2 question? 그래서 저는 이제 그 요건 입증을 제가 질문의 포인트를 다시 좀 헷갈리는데 그 어떤 사람을 증거로 어떤 걸 증거 능력을 갖춰야 되는 질문이었는지 아니면 어떤 걸 입증해야 되는지 몰라가지고요.
Oh, no, the evidence that we can use from this case.
에비던스. 예. 그런 것처럼 이제 전직 2만 명의 난민들 가운데 그 A국 출신들 난민들의 증언을 모으고 탐사 보도 자료와 문서 그것 그리고 판결문 그리고 전직 구성원 중에서 체포한 당사자 증언 이런 것들을 다 수집해야 된다고 보고요. 그 비밀 경호국 당사 그 기관의 그 증언자가 포함돼야 된다고 보고요. 북극곰이라고 하는 구금 위치 그리고 구금의 그런 환경들을 증언을 다 모아서 해야 된다고 봅니다.
Do you mean the database that was hacked?
두고 그 에비던스를 갖춰야 된다고 생각합니다.
This is a really interesting case here, because actually it brings us to the last part of this workshop. I wanted to speak with you about evidence that is necessary for a court case. And I just wanted to stress that from my experience, for documentation work, it is extremely important to know the rules of evidence of a specific state, because the standards of proof can vary a lot. So what do I have to prove? Do I have to prove it beyond reasonable doubt, or must it be more likely than unlikely that this crime has been committed? And there are also different rules on when evidence is admissible. And in fact, a very important rule in many states is that evidence which was obtained when torture or ill treatment was used cannot be admissible in a case. However, there are certain exceptions, and this can be very important when we're speaking about hacked information, which of course, especially in countries that are very sealed up, can be crucial. So whether it is documents, whether it is a database or anything else, this can be very important. And also something that we spoke about very briefly is the chain of custody. So it is important that you're able to prove where evidence comes from, because you need to prove that it is reliable, it is authentic, that it's not just fabricated evidence. So this can be important as well. We're coming to the fourth question. Which risks do you see and how could you mitigate them? Does anyone have any opinion on the risks that are at stake here in the case?
I see a risk. One risk. This is not a legal risk, but I just see a more humanitarian or risk to the family. The husband who's remaining in the state, I think would be my biggest concern amongst all of them, because he is still in state A.
Thank you. This is great. Indeed, retaliation can be a big risk for the relatives of the victims who remain in the country and thus under the control of the authorities. Is there maybe anything else you see?
And also, X's mental health is drastically deteriorated. Going through the whole due process might make her mental health even worse.
Thank you. That's also a very important point. The re-traumatization of victims, whether during the documentation process or during the process in the court that will follow, is a real risk and should always be part of the risk assessment for your strategies when it comes to that. So the fifth question is, if we file a case in State C based on the Rome Statute and based on the crime against humanity, as you know, we would need to prove that there is this contextual element. So we need to prove that there is a widespread or systematic attack against the civilian population. And I'd be very interested to hear what you think, what evidence could support this claim, because as you know, if you file a case in a court that is not very familiar with the political or human rights situation in another country, it can be crucial to prove that the situation is indeed dire and amounts to crimes against humanity and to an attack. So is there maybe from the case any evidence that you think could help us in this case? I think it's mentioned rather in the beginning when it speaks about the situation in the country. So from our experience, or was there an answer? Sure.
You asked for possible solutions
Yes.
or something. I don't know if this would be helpful, but I know that since it mentioned the hackers, they had found some evidence of the crimes within, the polar bear prison. And since they retrieved the information in kind of an illegal manner, so they kind of can't be admissible in court, maybe since they have this evidence, they can try to find a legal route to request that evidence from the prison, like asking if there are records of this person existing, and if not, they can maybe try to find an investigation in that prison through legal matters to be like, oh, well, we have other evidence saying that this person did exist, so would you mind us trying to dig and see if that is true or not, that kind of thing.
This is great. Otherwise, I think, oh, Bono, sorry.
I have a question. So you pointed out at the beginning of the case study, so are activist lawyers and anyone who is perceived to be disloyal to the authorities considered a quote-unquote protected class or a very specific group within society that could be considered as because it needs to be targeted to a very specific identified group for it to be considered a crime against humanity?
Well, if we spoke about persecution, then yes, it would need to be a political group or an ethnic or national group, for example, but for crimes against humanity, we only need an attack that is directed against the civilian population as a whole. So in this case, we wouldn't need to make an assessment and to differentiate between them.
Okay.
But we could use, for example, the report of the UN Special Rapporteur, as we have a mandate, thankfully, for this situation. And indeed, any other reports from authoritative sources, whether from investigative journalists, whether from other NGOs, whether from other UN bodies, or other intergovernmental organizations can help us in this case. And we are coming to the last very practical question now, question 6. If you needed to compile a budget for this project, which costs would you include and why?
네, 일단은 그 시국에서의 뭐 소송, 뭐 기소하는 비용 마련돼야 될 것 같고요. 전 시간에 배웠는데 NGO들과 함께 연대해서 펀드레이징을 해야 되겠죠. 그리고 증언 자료들을 통역하고 번역하는 자료들을 이 모든 부분들 비용이 들어갈 것 같고요. 그리고 증언자들에게 대한 비용, 또 체류 증언하는 활동 기간에 대한 체류 이런 모든 것들이 비용이 들어갈 것 같습니다. 예, 그리고 이것 6번 답변 된 다음에 질문 다시 한번 드리겠습니다.
Of course. Does maybe anyone else have an idea on question 6? Because I think your answer was very complete. So, yes, sure.
Would you have to also...
Oh, I think it's with the mic.
Yeah, I think he did answer your question, but I have a question. Would you also be including in the budget the costs for the victim's mental health as well? Is this something you would think about, or is this something that's kind of outside of your boundaries, I guess?
I think this definitely depends a bit on the mandate of the organization you're working for and the possibilities you have in your country, whether there is support that is free of cost or whether you would need to pay for this or whether there are insurances that can help. But in fact, I would definitely include this. Thinking of psychological, but also social and broader financial support if that's possible. Okay, I think we're done with the case study. Thank you so much. Well, thank you. Okay, so let's start with the Q&A, if you have any other questions.
예, 정말 궁금한 질문이거든요. 네, 그건 뭐냐면 그 5번과 질문과 좀 연관이 있는데 지금 비밀 경호국 요원 그리고 사례를 가담했던 그 책임자를 법정에서 증언자로 세운다고 하더라도 그 가해자는 현재 시국에 있지 않고 이 경호국 요원을 통한 증언을 하고 법정에 세워서 증거 능력을 갖춘다 해도 해당 A국에서의 책임 당사자 범죄자는 없는데 나중에 걸석 재판이 가능합니까? 이어서 계속적으로 이런 경우에 그 A국에서의 범죄자가 시국으로 못 오는데 걸석 자리가 없어도 재판이 이어질 수 있는지 궁금한데요.
Well, given the political, well, first of all, thank you for your question. I think given the situation in State A, I'm not sure if there will soon be a trial. But if there was, I think it really depends on the legal system. There are legal systems that allow for trial in absentia, and there are systems that do not, or on very limited, very limited exclusions for this rule. This really depends on the legislation. Unfortunately, there is no universal rule. But it can be possible. It does not always violate human rights law.
Thank you, Alexandra, for your presentation and the nice case study. Just have one question concerning the Harowski case. You mentioned the importance of the local lawyer for this kind of litigation, impact litigation. In that case, how did you find the Swiss lawyer who helped with your cause in the country? Thank you.
Well, thank you for the question. Actually, this is exactly the case when a partnership with another organization was very beneficial for us, because as you know, we had two partner organizations in this case, and Trial International is a big international organization that is specialized in litigation and in criminal accountability, and they're based in Switzerland. So it always helped to have an organization that is based in the country where the trial will take place. And in this case, we got his contact over our colleagues from Trial.
너무 잘 들었고요. 어떻게 보면 우리 피해자들로서 증거를 제출한다 해가지고 지금 중국하고 북한 당국에서 강제 송환이 지금 제일 중대한 사안이잖아요. 그래서 중국에서 작년에 아시안 게임이 끝나고 바로 600여 명을 기습적으로 송환을 했어요. 송환을 하면서 국제적으로 압박을 하니까 자기네 자국 내에서 탈북민들을 강제 송환을 한 유엔에다가 정식적으로 보고서를 낸 게 9월 14일에 제출을 했더라고요. 기사를 보니까 그렇게 말했어요. 자기네 자국 내에서 보낸 탈북 강제 송환한 사람들이 북한에서 고문받은 증거가 없다고 이렇게 했어요. 그리고 이번에 지난 4월 말에 또 60여 명을 또 강제 송환을 했잖아요. 또 똑같은 대답을 하고 있어요. 제가 말하자는 거는 우리가 북한 강군 피해자 가족회가 생존자들이고 고문 피해 당사자들이에요. 그러면 우리가 제일 대한민국에 탈북을 해서 도착을 해서 우리가 건강검진이란 거 인천 적십사사에서 제일 먼저 하는 게가 그걸 받는데 의학적 진단서가 있어요. 고문을 받아서 북한에서 고문을 받아서 저 같은 경우 저뿐만 아니라 우리 회원들이 여성 피해자가 굉장히 많고요. 중국에서 강제 인신매매를 당한 여성 회원분들이 여성 피해자들이 거의 80%를 차지하고 있어요. 그러면 이분들이 저도 지금 한국에 어제는 정착한 지 11년 되는데 외상후 스트레스라는 진단을 지금 그냥 지금 안고 있고 약을 복용하고 있어요. 그리고 그러면 의학적 진단이 있잖아요. 그게 확실한 증거가 될 수 있는지. 그리고 그다음에 증거를 그렇게 하고 그다음에 우리가 북한에 남겨진 가족들 때문에 이렇게 북한이 폐쇄적인 국가니까 그 가족들 때문에 이렇게 증언 그런 데도 못 나서는 분들이 좀 있어요. 그렇지만은 그 가족이 다 왔다거나 그다음에 아무것도 없어. 그러면 어제는 있는 그런 분들이 나서서 이렇게 국제행사재판소에 중국을 압박할 수 있는 그런 증거가 의학적 진단서뿐만 아니라 그리고 고문으로 인해서 이렇게 여기 대한민국에 와서 장애 등급을 받으신 피해자들도 있어요. 그걸 확실하게 좀 말씀해 주셨으면 좋겠어요. 중국을 어떻게 압박할 수 있는 그게 확실한 증거가 되고 어떻게 국제적으로 할 수 있는지.
Yes, for sure. Thank you so much for sharing this. Indeed, the reports of medical examinations can be a very strong evidence in torture cases, and torture cases in turn can be an indicator for crimes against humanity and for the contextual element. So indeed, this is very important evidence that can be used. Okay, I don't see. Okay, sure.
I know that in international courts, the discretion of the chambers is quite wide, large when it comes to the admission of evidence. And I wonder in domestic practices, how often it's been the case that the barrier is too high, that important evidence couldn't come in because, for example, they say it's hearsay evidence, or because there's a question of authenticity. How has it been a lot of, I mean, have you been in situations, or your organization have been in situations where important evidence couldn't come in because of these high barriers? Like very, very important things that could change the case, I suppose.
Thank you so much for this question. So far, I have not been in the situation that evidence was not admitted because of that. Working on the appeal of the case in Switzerland, this can become an interesting question, but I cannot share more at the moment. I would say that from my experience and from our experience, national courts tend to be stricter when it comes to evidence and the admission of evidence. However, this can depend on the legal system and even on the persons in the situation, so the judge and the discretion. So it's really an individual case-by-case analysis. But I think that as a strategy, we should try everything we can as NGOs, of course, in the context of legality and in the context of what is admissible, to file important evidence, because it can be key to resolving these cases and achieve accountability.
So you haven't been in situations where very vital important evidence couldn't come into domestic? So there hasn't been really a situation where vital evidence couldn't be admitted to domestic jurisdiction because of these barriers? So you haven't faced that yet?
Me personally, I haven't faced this yet. However, even if information is admitted, we need to see how it is used. We are running out of time, right? No. Thank you so much. Okay. Last question then. Okay.
예. 그리고 그 강제 송환된 그 여성들이 가서 북한에 가가지고 그 안에서 다 돌아오지 못한 분들이 많아요. 그래가지고 다 돌아가가지고 중국에 남겨진 아이들이에요. 그러면 그 강제 인신매매 당해서 중국인이잖아요. 남편은. 그리고 그 여성들은 가가지고 다 돌아갔으니까 오지 못하고 그 버려진 아이들이 수두룩하단 말이에요. 중국에. 그러면 이제 그 우리가 법적으로 국제행사재판소에나 기소를 한다고 할 때, 그러면 그 어느 나라를 더 강하게 우리가 책임을 물을 수 있는지 그거 좀 답변을 좀 듣고 싶어요. 아이들에 대한 거.
I will give a very brief answer, and I'll be happy to discuss this after the end of the workshop. From what I see right now, although I do not focus on ICC investigations, but on domestic investigations, the question is whether the ICC would have jurisdiction to decide on any of the cases, because unfortunately neither North Korea nor China are a member to the Rome Statute. So the question would be how the case could be filed. But again, very happy to discuss this after the end of this workshop. Yeah, so thank you so much for your participation, and